Okay, let's dive right in. For so many inventors, filing that provisional patent application feels like this huge sigh of relief, right? It's like you've got this 1-year safety net. But what if that safety net has some really big, really serious holes? Today, we are breaking down that critical 12-month window. We're going to uncover the common and often very costly misunderstandings that can put your entire invention at risk.
So here's what we've got on tap. First, we are going to bust the 12-month grace period myth wide open. Then we'll get into the reality of the unforgiving clock and what actually happens on day 365. From there, we'll talk about the strategic opportunity this window gives you, and I'll ask our expert about the single biggest mistake they see inventors make. And finally, we'll wrap up with how to build your strongest case. And to guide us through all this, we have a special guest with us today who spent over 2 decades as a patent examiner at the USPTO.
All right, let's just tackle this myth head on. There's this idea out there that the provisional application is basically your get-out-of-jail-free card for a year. You know, a time to just kick back before the real work has to start. I mean, you see this quote right here. This is the exact mindset we're talking about. This feeling that you're in some kind of safe harbor for a year. So I got to turn to our expert here. From your perspective, having been inside the USPTO, how dangerous is this way of thinking? It's not just dangerous, it's a trap. It's a complete trap. That false sense of security is an illusion, and I've seen it sink countless great inventions from the inside. The hard reality is that clock is not your friend. It is a relentless, absolutely unforgiving force working against you from the very first day. Let's be crystal clear about this. The pendency period is exactly 12 months. Not one day more. It can't be extended. The system doesn't care if you were busy or had good intentions. It is an absolute, non-negotiable deadline, period. And this is the part that really trips people up. The law itself, we're talking 35 U.S.C. 111b5, says the application automatically abandons. It doesn't get rejected. It doesn't get a second look. It just ceases to exist. Poof, it's gone, and there's no reviving it. It's one of the hardest stops you will ever find in the entire legal system. And here's the real kicker, the thing that just shocks so many inventors. You will not get a reminder. Not an email, not a letter, nothing. The USPTO is not going to tell you that your deadline is coming up. The responsibility is 100% on you. The system is designed to be automatic, and it just assumes you've marked your calendar. Okay, wow. So we've established the deadline is ironclad. The consequences are, well, they're severe. But let's shift gears here for a second. This 12-month window isn't just about a threat, right? It's also a huge strategic opportunity. So I'll ask our expert, how should inventors actually be using this time? That's exactly the right question to ask. This is absolutely not a passive waiting game. This is your window to refine the invention, to seriously assess its commercial viability, and, I cannot stress this enough, to conduct a thorough patent search. Speaking as a former examiner, one of the most common things we see are non-provisional applications that clearly skipped this homework. They land on our desks with these weak claims that are pretty much impossible to defend. And let's not forget, this is also your one and only shot to prepare for international filing under the Paris Convention. This timeline you see here, it's a great roadmap. The first few months, that's all about finalizing your research and testing. Then you move into a professional search to really nail down what your claims are. The heavy lifting, the actual drafting of the full non-provisional, that should be happening between months 9 and 11. And here's a pro tip. Always, always target month 11 as your real deadline. Waiting until day 365 is just playing with fire. One little technical glitch with the filing system, and you're done. Remember, that deadline is absolute. This is fantastic insight. So the deadline is a hard stop, and you need a solid game plan. So it seems pretty obvious then that the biggest mistake an inventor could possibly make is simply missing that deadline, right? I mean, after everything we've heard about that unforgiving clock, that has to be the ultimate failure. So I have to ask you straight up, is that the #1 mistake you've seen? No. And if you take only one thing away from this whole explainer, please let it be this. Missing the deadline is catastrophic, don't get me wrong. But the more common and frankly far more insidious failure is filing a provisional that's just too thin, it's too narrow to actually support the invention you end up with 12 months later. Let's really break down what that priority date means. Think of it like a snapshot in time. It only protects the technical details you put on paper on that exact day. So if you make improvements or add new features over the next year, and most inventors do, Those new things do not get the protection of that original filing date.
And I want to be really clear here. This isn't some obscure legal theory. As examiners, this is something we check directly. We literally pull up the original provisional filing, and we compare it, side by side, to the final claims. If we see new material in the final application that wasn't in that original snapshot, those claims get a later filing date. And that could leave them totally vulnerable to competing inventions that came out in that time in between. So the quality of what you file at the beginning is just as important as the timing of what you file at the end. That brings us to our final section, the real-world outcomes. What actually happens when that 12-month clock finally runs out?
So when that 12-month clock hits zero, you're really looking at one of three basic outcomes. Scenario 1, that's the goal. You file on time, and your provisional has done its job protecting your non-provisional. It's scenarios 2 and 3 where things can really go sideways.
Scenario 2 is, well, it's the nightmare scenario. If you have publicly disclosed your invention in any way, you sold it, you presented it at a trade show, you published an article, and then you let that provisional expire, you may have just permanently forfeited your patent rights. That combination of public disclosure plus a missed deadline, that's a mistake you often can't come back from.
This right here is the whole ballgame. The goal isn't just to survive the 12 months and get something filed on time. That year is the active, critical period where the quality of your technical disclosure determines the actual strength and the real value of the patent you might get down the road. A weak provisional will always lead to weak protection, even if you do everything else right.
This has been a fantastic look at what's really happening behind the curtain during that 12-month window. If you want to see that detailed month-by-month action plan and really get a deep dive into those 3 expiration scenarios, you can read the full article this explainer was based on over at ipboutiquelaw.com. Thanks so much for joining us.